Today we are honored to have Professor John Quigley here in our new YouTube program concerning international and domestic trending legal matters, of which presenter I will be. Professor John Quigley is Professor of Law in Moritz College Law of Ohio State University. Professor Quigley stands out not only an international law and comparative law expert, he has also extensive experience and publications on the Palestinian issue. Furthermore, his significant contributions extend to Genocide Convention. In 2006, he published an extensive analysis on Genocide Convention. I'm an international lawyer as well, definitely quite a junior one compared to Professor Quigley. I'm faculty member at Istanbul University and PhD candidate in the same school in international law. I am also registered at Istanbul Bar Association. Okay, Professor Quigley, I would like to start with my first question. Israel decided to defend themselves in the ongoing case before the International Court of Justice. It came as a surprise to some. What do you think? Did this decision come as a surprise to you?
It did not come as a surprise that the case was filed by the Republic of South Africa. There is strong evidence that genocide is being committed in Gaza by the government of Israel. The question of genocide has been widely discussed among experts for the last several months, and we in fact were just waiting for some country to decide to file a case, and it turned out to be South Africa that decided to take that step.
Okay, initiation of this case didn't come as a surprise to you. It's what I understood from your answer. But I aim to ask whether the decision of Israel to defend itself in this case came as a surprise or not. Because some commentators obviously were expecting them to protest this case.
Exactly. I was not certain whether Israel would defend itself in the case because the attitude of Israel to the United Nations has been to dismiss what it has been saying about its invasion into Gaza. But apparently the government of Israel decided that it was in Israel's interest to respond. Namely, that if South Africa were to go into the court and explain that Israel is committing genocide, if Israel did not respond, it would appear that Israel was conceding that it is in fact committing genocide.
The merits phase of the current case has not started yet. We just had the proceedings regarding the indication of provisional measures on 11th and 12th January 2024. But even though these proceedings were only concerning the indication of provisional measures, it must have given some preliminary thoughts, ideas about the stance and arguments of the parties. So how would you evaluate the arguments laid down by both sides?
I think the argument laid down by the Republic of South Africa was very strong. It presented a great deal of factual evidence about the humanitarian crisis that has been generated by Israel. And that is the essence of its case, namely that by depriving the population of the availability of food, of fuel, of water, that the government of Israel is creating a condition which is calculated to inflict the conditions of life that will result in the physical destruction of the population. So I think that the case by South Africa is very strong. The response by Israel has been to say that Israel can defend itself lawfully, and that therefore what it is doing is not genocide. This is not a valid response in international law, because the obligation to prevent genocide, to refrain from committing genocide, applies in all situations. Even if Israel had a right to defend itself in Gaza, it would not be authorized to commit genocide.
Okay, this point is very important. Just to lay emphasis on that, I would like to ask again. So Israel's counsels are arguing that Israel is using its right to self-defense. But even if it's true, of course it's controversial whether it's true or not, but even if it was true, you still highlight that it does not relieve Israel from the obligations arising from the Genocide Convention, right?
Exactly.
Also, related to this point, I would like to ask that Professor Malcolm Shaw, a distinguished international law professor and also one of the counsels of Israel at the ongoing case, stated that all conflicts with immense destruction still cannot be qualified genocidal. So what's your thought on this statement? So what makes it genocidal or not?
Yeah, that statement is true as far as it goes. That is, it is often the case that civilians are killed in wartime. I think that was his point.
Yeah.
But in this situation, we have the intent for genocide. That is the intent to create a situation where there will be physical destruction of the population. So it is more than simply the fact that Israel is killing people in wartime. This is a rather unique situation for warfare, in that the population is confined to a certain geographic area. So it is dependent on what it can get for sustenance of the population, and Israel is aware of that. So the Israeli government, on the 13th of October, ordered the evacuation from the northern part of Gaza, knowing quite well that the population had nowhere to go, and that it would not be able to sustain itself in the areas to which it would be going. So that is the essence of the charge of genocide, that Israel acted in a way that it knew the consequence would be the destruction of the population, not necessarily the entirety of the population, but a portion of the population. And that is all that is required under the Genocide Convention. So it constitutes genocide if a state inflicts on a population such conditions as are calculated to bring about the physical destruction, either in entirety or in part.
So even partial destruction is sufficient to claim that there is a violation of Genocide Convention.
Exactly.
After the proceedings for the indication of provisional measures, what is your expectation? Do you think the ICJ judges will decide on provisional measures, especially taking into consideration the recent precedents they demonstrated in the cases against Russia and Myanmar on the same basis?
Yes, you make a good point that there have been two recent cases on genocide, and in both cases, the court has issued provisional measures. What is required for the issuance of provisional measures is a determination that South Africa has a plausible case against Israel under the Genocide Convention. The court does not need to decide definitively whether South Africa has a valid case. This makes it much easier for the court, but the court must decide that the case is plausible. So if the court does issue provisional measures, it will in effect be saying that the case against Israel for genocide is plausible. But given the way the court has dealt with the Myanmar case and the Russia case, it does seem likely that the court will issue some provisional measures. The question is, what provisional measures will it indicate? Will it say that Israel should refrain from committing genocide, or will it say Israel should refrain from committing genocide and that Israel should withdraw from the territory of Gaza? In the Russia case, the court did say that withdrawal from the area was required as a way of resolving the dispute. So this, to me, is the major unknown issue right now, whether the court will order Israel to withdraw from Gaza. That is being requested by the government of South Africa.
So you don't have any clear expectation about this point? I mean, about the possible provisional measures that can be decided?
I don't have a good prediction on that issue. The lawyers for South Africa cited the Bosnia case, where the court issued provisional measures under the Genocide Convention in 1993, but did not order a cessation of military activity entirely. The court only ordered a cessation of genocide. So the lawyers for Israel are suggesting that if the court says that Israel is committing genocide, it should refrain from ordering Israel to cease military activity entirely.
Israel's counsels are also asserting that any indication of provisional measures to cease the current conflict would actually impede the inherent right of Israel of self-defense. Because if it is ordered to stop the entire military operation, they cannot defend themselves effectively anymore. This is the argument, the main argument, or one of the main arguments of Israel's counsels. What do you think on that point?
The court can order a state to do what is necessary to prevent it from continuing some violation of law. So if the court thinks that the humanitarian situation cannot be addressed adequately while the IDF continues to operate in Gaza, it could give that kind of an order, regardless of whether Israel has a right to defend itself.
So this argument is not an obstacle for the indication of provisional measures to stop the conflict completely?
I would say so,
yeah.
yes.
And Professor, let's assume that the ICJ gave a decision against Israel, be it provisional measures or be it the main judgment after the merits phase. We know that Israel is 100% bound by such a decision coming by the ICJ, but what would happen if they decide not to comply with the decisions of the court?
Once the court issues an order, it will communicate that order to the Security Council of the United Nations, because the Security Council, according to the UN Charter, has the obligation to enforce decisions of the court. So that would put the matter into the Security Council. And the Security Council could invoke articles of the UN Charter that give the Security Council the power to order sanctions against a state, diplomatic sanctions, financial sanctions, or even military sanctions, even to organize a military operation to implement the decision of the court. The question at that point would be the attitude of the United States and whether the United States would veto such sanctions. The United States might feel that it is under pressure from other states of the world and would refrain from veto. It could decide to abstain on a resolution to institute such measures, in which case the resolution would be adopted. Or if it does veto, the matter could be taken up by the General Assembly of the United Nations, and the General Assembly could recommend the same kinds of sanctions. If Israel were to fail to comply at that point, then it would be up to the states of the world to decide what to do and whether to institute those sanctions against Israel.
Also, it's not just a matter of the United States, I believe. There is still United Kingdom, France, who may also use their veto right in favor of Israel. That's my personal belief. I have a question related to, let's say, the second step that you indicated. Let's assume the Security Council, UN Security Council, somehow used its veto power. I mean, the permanent members of the council used their veto power, be it the United States or others. In this scenario, when the case is referred to the General Assembly, the decision will be taken by General Assembly will be just a recommendation decision. It will not be binding, right? So they cannot take any binding action.
That's correct.
Yeah.
So it would depend on the will of governments to act on the recommendation.
Yeah.
So during the war in Korea in 1950, such a resolution was adopted by the General Assembly, and a number of states did act on the recommendation and organized military action. So there is a precedent in that regard.
But it's not as strong as any Security Council decision. So would you agree on this, the following statement? The system can fall into a sort of loophole because non-compliance with the ICJ's decisions are actually presumed to be sanctioned by the United Nations Security Council. But United Nations Security Council have some permanent members who can use their veto rights in favor of Israel, and they can actually refrain from sanctioning Israel. It's a sort of loophole in the international legal system.
Yes, what you say is very possible, that the General Assembly could recommend certain measures and that they would not be implemented.
Almost in each time when when the Genocide Convention's jurisdictional clause is invoked by some states, the other party of such case argues that it is abuse of the jurisdictional clause of the Genocide Convention. What's your take on this debate?
Well, there is a question about the jurisdiction of the court. The court has said previously that when an allegation is made under the Genocide Convention, a case may be instituted by any state that is party to the Genocide Convention. That is the basis on which the Republic of South Africa initiated this legal action, because Israel is party to the Genocide Convention and South Africa is party to the Genocide Convention. However, under the convention, there must still be a dispute between the two states about the commission of genocide. And in the argument in the International Court of Justice, the legal consults for Israel argued that there is no dispute between South Africa and Israel about the commission of genocide in Gaza. And Israel's lawyers argued for a very long time on this, because I think they see this as their best opportunity to avoid an order on provisional measures. Now, South Africa knew that this argument would be made by Israel. So Professor Dugard, arguing for South Africa, said that there is indeed a dispute, and he explained that South Africa had already filed a complaint with the International Criminal Court against Israel for genocide, and that it had made representations to Israel, and that Israel was denying that it has committed a genocide. So this same issue arose in the Myanmar case.
Exactly.
Where Myanmar said that Gambia and Myanmar did not have a dispute, and the court decided in favor of Gambia and said that there was a dispute. And I think that South Africa's case for there being a dispute is stronger than Gambia's case was for there being a dispute.
So this attempt or these attempts cannot be described as abuse of jurisdictional clause of the Genocide Convention.
Not at all.
Oh. And you are an Harvard alumni. If I'm not wrong, your bachelor's degree and also master's degrees are obtained from Harvard Law School, right, Professor?
Yes.
Okay. So as an Harvard alumni, how do you see the dismissal of the president of Harvard University after all debates related to Israel's operations in Gaza? How do you see it? I'm wondering.
Well, there has been an effort on the part of certain political elements in the United States to attack the major universities. When the issue with Gaza first arose in October, the president of Harvard issued a statement saying that students at Harvard should not publicly say that Palestine should be free from the river, from the Jordan River to the sea, to the Mediterranean. I sent a message as an alumnus of Harvard to the university criticizing the president of Harvard and saying that this was a violation of the rights of freedom of speech for Harvard students, that the president would tell them not to take such a position. Then the president was called to Washington to speak in Washington to defend what she was doing, and she was criticized for taking insufficient steps to prevent anti-Semitism at Harvard. But the allegation was that she was not taking sufficient steps to stop the demonstrations in support of Palestine. So I did not think that there was a question of anti-Semitism there. It was a question of Israel's war, and was not a question of bias about Jewish people. So at that point, I switched my position and I became a supporter of the president of Harvard.
Thanks a lot, Professor.